Ladies and gentlemen, thank you for standing by. The National Alliance for Radiation Readiness and the Association of State and Territorial Health Officials present the radiation and public health legal considerations. During the presentation, all participants will be in a listen-only mode. Afterwards, we will conduct a question-and-answer session. At that time, if you have a question, please press the 1 followed by the 4 on your telephone. If you would like to ask a question during the presentation, please use the chat feature located in the lower left corner of your screen. If you need to reach an operator at any time, please press *0. As a reminder, this conference is being recorded Wednesday, September 18, 2013. I would now like to turn the conference over to Andrew Rozak. Please go ahead, sir.
Well, thank you very much, and I'd like to welcome everybody to the conference today, the webinar, on behalf of the National Alliance of Radiation Readiness and our partners over at ASTHO. I'm Andy Rozak. I serve as the Senior Director for Environmental Health, Pandemic Preparedness, and Catastrophic Response over at NACCHO, the National Association of County and City Health Officials. And we're very excited today to talk about a project that we've been involved with for about a year now, looking at the legal considerations of radiation responses. And I would be remiss if I didn't up front thank our partners, again with the NAR, and also the great work done by CDC on this project, in particular our friends at the Radiation Studies Branch, Jennifer Bazell, and also the folks at the CDC's Public Health Law Program, Matthew Penn and Donald Benkin, in addition to Gabriella Claves, who's really been the workhorse and the key researcher on this project. So we'll get right into it today, and we'll make sure to leave some time at the end for some questions and hopefully some discussion. So as many of you are aware, it's been a significant amount of time since we had a domestic issue of any radiological concern or notice here in the United States. Really the last time was in the 1970s with 3 Mile Island. And since then, there just hasn't, knock on wood, been a lot of radiation incidents that have really gotten national attention. So that being said, we're about 3 or 4 generations out from all the exercises and drills and really experience of preparing for radiation. Now obviously the events of the last couple of years have changed this as we look overseas and some of the incidents that have occurred there, which really prompted us to re-examine some of the preparedness issues and response and plannings that have occurred in the United States on radiation elements. So as many of you know, over the past several decades, there's been a lot of planning and preparation that has gone on. However, the legal patchwork of the laws that underpin any kind of a response or recovery efforts have largely been unexamined. So to address these issues, NACCHO engaged in a very collaborative effort with CDC to help examine state and local legal authorities related to the response and recovery from a radiation incident. And that's what we're going to talk about today. So at the onset, I think it would be helpful to define kind of the scope of the project. And we weren't, obviously this is a huge topic, so we really were looking at the relevant state and the relevant state and local legal authorities associated with isolation and quarantine, decontamination, and epidemiological studies involving radiological materials. To look at these issues, we developed a working group, and the working group consisted of public health officials, radiation subject matter experts, attorneys with knowledge of public health practice and operations, and also law enforcement officials with expertise in radiological incidents. And we had a tremendous work group. I see several of our work group members are on the webinar today, and I'd like to thank you all personally for participating and sharing all of your knowledge and expertise with us. We had some very robust discussion. We met 2 times via webinar, and we met in person at the Preparedness Summit last year, and then we reconvened a smaller working group at the NACCHO annual conference back in July to really look over the issues that we've discovered and try to hash out a guidance document which we'll hopefully be able to share with you publicly in a few months. The process, the guidance document now is being vetted, and we'll go through the clearance process, and then it should be released to the public. And we're hoping to get that done in the very near future. So I guess at the onset we should also talk about, why is this a state and local issue? What is the focus on state and local laws? Why does that matter for radiation? And the answer is pretty simple. The federal government is a government of limited powers. Its constitution helps to serve the framework of which the laws are implemented and carried out in this country. So really, unless a power is specifically enumerated to the federal government, the power is reserved by the states. So when we look at things like isolation and quarantine and decontamination, most of those fall under the police power of the states. So the enumerated powers that are listed we're all familiar with. That's the power to tax and spend. It's the Commerce Clause power, which regulates interstate activity, national security power, and then of course things that are necessary and proper. So these are pretty broad exceptions, but they really don't cover the isolation and quarantine issues that we're examining here. In fact, when you look at the federal legal authority for isolation and quarantine, Executive Order 13375 has actually limited that quarantine power to 9 diseases. And we'll highlight for the first time and many times throughout this presentation that these are diseases, and these are communicable diseases, which radiation does not fall into that category. It's not a disease. So in addition to the Constitution, we have reaffirmation of the principles of enumerated powers and limited power of federal government through the 10th Amendment, which says that any power that's not delegated to the United States by the Constitution is specifically reserved for the states. Thus we have that broad grant of plenary power and of the 10th Amendment reaffirming that plenary power so that the states maintain the power, and that's why you see the states have such a role in healthcare, in particular licensing and credentialing and regulation of the healthcare industry. So along in that train of thought, if the powers are really at the state level, then it's important for us to just be aware of what context we're functioning under. And as we have seen throughout many disasters, and this particular slide talks about Katrina, but it's true for almost every disaster, especially the recent ones such as Sandy, we see this large dispersal of people after a disaster happens. In fact, every state in the country saw some kind of displaced population from Katrina. So as we're thinking about a radiological incident that were to occur, our planning tells us that it's likely that people are going to scatter. And as we look at the different laws and authorities in different states, this could potentially be problematic as different states have different authorities. So just something to keep in mind, the borders or the disasters know no borders. It's not like the radiation gets to a state border and stops. Obviously that doesn't happen, and the weather patterns don't follow that rule either. So we need to just be cognizant of what the legal landscape is in every state, and especially in our neighboring states, to figure out how to really plan for responses. And here's just a map showing the nuclear power plants that are throughout the country. So you can see there's quite a few, in particular in the eastern part of the country and of course in the Midwest. So what exactly did we do? We did a 50-state survey. We also looked at Washington, D.C., New York City, and Los Angeles. And simply we asked, does the local or state jurisdiction have laws providing the authority to restrict movement of individuals who have been contaminated or potentially contaminated with radioactive materials? And the second question we asked was, does the state or local jurisdiction have laws providing the authority to decontaminate individuals who have been contaminated or potentially contaminated with radioactive materials? So those were really the two questions that we set out to examine across the country. And when we're looking at the laws and trying to read the statutes that are on the books, it's really a question of intent. So a reviewing agency such as a court really tries to boil down language into its most common element. And really we apply something called a plain meaning rule. So if the terms of a statute or a regulation are plain and unambiguous, that's the real meaning that we go for. We assume that the Congress here in Washington, D.C., and then all the legislatures throughout the country are sensible folks. And when they put something down on paper, they write what they mean. So if we can read something and use normal, ordinary definitions, that's what we're going to do. Likewise, we give words in a statute or regulation their ordinary or dictionary type meaning. And you'll see this come into play a little bit later here as we talk about the different authorities. So another tool that courts use in resolving ambiguity is called the Canons of Construction. So there's many different ways that we can try to reconcile a statute or a law that's on the books. The first, as I just mentioned, is the common meaning rule. We look to make sure that the laws say what they say, and we take that as kind of face value. But if there does become a question of what the language means or what the legislative intent was, we have some tools in our arsenal that we can deploy here. And one of them is looking at legislative history. So looking at the debates that occurred, the transcripts from committee hearings, if people enter comments as they vote. Another thing that we use is called the Canons of Constructions. And canons are not rules of law. They are merely principles that a court uses or may use for help in deciding what a statute or a law actually means. So one of them is Ejusdem Generis, and that means of the same kind or class. So when a general term follows a specific term, the general term will be read as including only things that are like the specific term. For example, a regulation that applies to cars, trucks, motorcycles, and other vehicles is likely going to be interpreted as not applying to boats or airplanes. Again, cars, trucks, motorcycles, all methods of ground transport. The court would normally say, based on this canon of construction, then boats and airplanes wouldn't apply. And this will, again, come in handy when we talk about the different classes of statutes that we examined. Another canon of construction is expressio unis est exclusio ulterius, which means that the mention of one thing excludes all others. So if one or more specific items are listed without the use of any general or inclusive terms, the others are excluded. So for example, the transportation of prohibited items in cars and trucks might not be read as covering motorcycles. So this is when you start to spell out things specifically in a statute that the courts are going to look at that and say, well, if you took the time to list cars and list trucks, then clearly you didn't mean motorcycles because otherwise you would have listed it here. And this is a good argument to have with your kids. If you say, I don't want you to have Skittles or Twinkies or cupcakes, then they could come back and say, well, Mom, you didn't say, ice cream and gobstoppers and things like that. So I guess what does this all mean? This all means that language really does matter. And we've got a few different findings that this assessment has led to, and this is the first major finding, that language matters. So when we look across the country and look at the various laws that are on the books, we find that states fall into basically one of four different categories. There's a category of express radiological language. There's a category of broad language, a category of narrow language, and a category that's limited to biologics. And we've got a slide for each of these, so I'll go through these one at a time. So express language. Express language is the language to restrict the movement or decontaminate persons with radiological contamination. The provisions of the law actually include the terms such as radiation or radiological agents. So for example, looking at the California Health and Safety Code, we see an example on the screen that says the local health officer may issue and first responders may execute an order authorizing first responders to immediately isolate exposed individuals that have been exposed to biological, chemical, toxic, or radiological agents that may spread to others. So again, looking at those canons of construction that we just looked at, we see biologic, chemical, toxic, or radiological. It's expressly listed. There's no debate about whether or not the legislature intended radiological agents to be covered in the statute. The next category is broad language. So some states give a whole bunch of authority to public health officials. And an example of this is in Alaska. So broad language is really, it's not linked to radiological agents, it's not linked to biologics, it's just a large, broad threat of a threat to public health or a hazard to health. So looking at the Alaska statute, you see the department may quarantine or isolate individuals who have been exposed to hazardous materials that can cause serious injury or illness by transmission of hazardous material to others. Again, just very broad language there. It doesn't specifically say it's got to be biologic or chemical or radiation, or it doesn't really talk about any of the CBRNE enterprise. It talks very broad terms, which is a good thing because obviously radiation would fit under this definition. The next kind of category we identified is narrow language. And this is language to restrict the movement of or decontaminate persons based on a particular condition or type of radiological release. So for example, out of North Carolina, if the state health director reasonably suspects that a public health threat may exist and that the threat may have been caused by a terrorist incident using nuclear, biological, or chemical agents, the state health director is authorized to order any of the following. And you see the list there. But again, you kind of caught that precursor that must come into play before this kicks in, right? So if the state health director reasonably suspects the threat may have been caused by a terrorist incident, that's a condition that needs to happen before he or she is allowed to do all these other things. So this is some examples of just a narrow language that applies only to a very limited circumstance. And finally, the last category that we identified is states that have language that is limited to biologic language. And this is limited to communicable and infectious disease law. So for example, out of New Jersey, a health officer or department, upon receiving a report of a communicable disease, shall by written order establish such isolation and quarantine measures as medically and epidemiologically necessary to prevent or control the spread of disease. Again, radiation, not a biologic, not a disease. Some would debate whether or not it's even communicable. So in this particular instance, it would be difficult to make an argument that this particular statute would cover a radiation incident. So in addition to the findings about the language and the categories, we've also had some more just kind of general broad findings. And the last slide with the Biologic statute kind of hits on this point. Many states and local jurisdictions use isolation and quarantine laws to decontaminate and restrict the movement of individuals. And historically, these provisions are embedded within infectious and contagious disease control language. And some may or may not actually deal with radiation. So it's perfectly acceptable and normal and probably expected that you would find the isolation and quarantine laws in the public health section of your code. You would find the provisions are tied to contagious diseases or communicable diseases. However, in retrospect, looking back, some states have, but other states haven't, actually taken that step to mention radiation in their statutes. So if that was the power that you're going to rely on to isolate, quarantine, decontaminate someone in a radiological event, you may be surprised to learn that that authority may not be valid. And the other major finding was that there's a big difference between what you can do every day during a non-emergency situation and what you can do when an emergency is declared. Once an emergency is declared, the ability for states or locals to decontaminate or restrict movement of folks can change, and can change dramatically. Typically, you'll see the power or authority given to the state or local health official broaden. And that makes a lot of sense, and that's something we want to encourage, obviously, during an emergency. We want all options to be on the table. So looking at kind of the landscape across the country, we tried to boil all this down and create some kind of a visualization that would make sense and kind of put all this in perspective. So what we came up with are these maps. So we've developed maps of the United States, and based upon the evaluation and the research and the assessment of the laws in that jurisdiction, we've attempted to color code them into those 4 specific categories. So the first map that I'm showing on the screen now is the map that governs the restriction of movement non-emergency authority. So this would be your isolation quarantine authority in a non-emergent type setting. So every day. So you can see by the map on the screen the states that have the express authority, where radiation is specifically mentioned, are in kind of a brown beige type color. States that have very broad authority are mentioned in a purple color. The states that have narrow authority are in a yellow color. And then states that have authority that seems to be limited to just biologics are listed in a blue color. In some states, there's argument that can be made both ways. In those states such as Texas, Missouri, Ohio, Alabama, you can see that we've dual shaded them. So now we'll move to the map of restriction of movement during an emergency. Like I said, the emergency declaration can change the makeup of the state's laws and authorities. And you can see quite a difference. In fact, let me advance the slide one more. And we can see the non-emergency up in the top left and the emergency authority on the bottom right. So you can see several states have shifted just based on the declaration of emergency. There's quite a few states that have went from broad authority to express authority. You see Oklahoma there going from limited to biologics in a non-emergency setting to a narrow authority exception during emergencies. Who else do you see there? You see South Dakota going from a limited to biological status in normal everyday operations to a broad authority status during emergencies. All right, well, we'll move on and look at some other maps. These are maps to talk about the authority to involuntarily decontaminate someone. And again, this is in non-emergency times. This is every day. And you see the map there of states that have express, broad, narrow, and limited authority. And then we'll switch over to the emergency authority map, and you see some of the colors that change. And I'll put both maps up here side by side. So again, you do see some shifting with the declaration of an emergency, which is what we'd expect. Again, you see Oklahoma that shifts. You see some movement there in Florida, going from a very broad authority to an express authority. That means they would actually mention radiation. You see North Carolina does some switching, as well as New York and Wisconsin. So again, depending on what type of function you're in, if you're in a non-emergency setting or an emergency setting, you're going to see some differences in your authority. So in terms of general themes, the authorities vary greatly. And as you could just see by the map, there's not a lot of, there's not an overarching color that comes out. And interesting, we put these maps up against the map you saw earlier of the power plants in the country, and there's really no correlation there either. So only about 15% of jurisdictions have express radiological language to decontaminate during a non-emergency. About 49% use broad provisions. About 4% have a narrow application for radiation. And about 32% of jurisdictions limit their decontamination laws to biologics. Obviously, this is going to really spread or really impact the ability that you have to respond and the legal considerations that will underpin your tactical approaches in response to any kind of a radiological incident. In addition, as we kind of noted earlier, you saw the wide disparity of colors. So if you happen to be in an express state and your neighbor is a state that limited to biologics, that's something you need to be aware of in your planning. Again, people don't know boundaries during a disaster, and certainly radiation and weather events do not know boundaries as well. So it's important to not only look at the context of your state and your authorities, but also to look at your neighboring jurisdictions and see where they lie on the map. When we look again at kind of general themes that we've discovered, isolation and quarantine. Again, many states have traditional isolation and quarantine laws to help decontaminate and restrict the movement of people. However, some of these are not, again, specific to radiation. Since a radiological release is not biologic, if you're relying solely on that communicable disease language and that authority to respond, you may not survive judicial review. And this comes into play a lot when we're looking at any kind of activity that's going to interfere or limit someone's personal freedoms. So a freedom of speech, a freedom of movement, a freedom of religious practice. All of these things could potentially come into play when you're isolating or quarantining someone. And also, again, general themes, emergency declarations. An emergency or public health emergency declaration may trigger other laws that expand or clarify the authority to restrict movement of individuals or involuntarily decontaminate folks. In many jurisdictions, that authority rests with the public health official or the governor. So for example, during an emergency, 15 states expand the authority of a governor. Such authority could contain language to control ingress and egress from a disaster area, and also the movement of people within that area. The language may grant the capability to control, obviously, who is allowed to enter or exit a selected locale. So these are important considerations to think about as you're making your preparedness plans, your response plans, doing your exercises, and also communicating with your partners. So what can we do about this? Well, we can do a few things. We can work with our partners to figure out what's the status of the legal authorities in our jurisdiction. And some of the questions you should be asking yourself is exactly that. What is the authority during a radiological incident? Am I in an express state? Am I in a biologic state? Am I in a narrow state? Am I in a broad state? How does that change during a disaster or during an emergency declaration? We should also take the opportunity to examine what kind of relationships exist between public health and legal officials. I'll tell you, a lot of attorneys and a lot of judges are not well versed on these issues. Many judges have never had to see or sign or deal with an isolation quarantine order. So if something like this was to occur at 3 o'clock in the morning, it may very well be the first time that they're ever dealing with this particular issue. And now you're trying to explain what public health is and what radiation is and why you need this order signed, at 3 o'clock in the morning on about when you have a 5-minute window to explain so to the judge. It could create some challenges. Again, are judges or public agency attorneys adequately prepared to assist you during a public health response? We know our law enforcement colleagues have figured this piece out. If they need to get a warrant or a subpoena or anything like that at 2 o'clock, 3 o'clock in the morning, they know what mechanism to go through. They know how to get a hold of the judge and have that order signed. Public health, maybe not so much. Obviously different jurisdictions operate in different ways, but I would take a guess that many public health officials don't have that number to call to wake the judge up at 3 o'clock in the morning. So that's where things like working with your local district attorney, working with your city or county or state attorney, working with your private legal counsel if that's who you have, but really come in handy prior to any incident. But also, what are your cross-jurisdictional relationships? We've said it a few times today about how different states have different authorities. And what does that do to impact your preparedness planning, response, and decision-making process? If you have a state that has a real broad authority to deal with these issues, is there a way to leverage that if you're in a state that only has authority limited to biologics, and vice versa? Again, whom would one need to contact after a radiological incident to legally decontaminate or restrict the movement of individuals? Do we have those contacts in place? And really, you know, it's clear to me that we have that authority. I mean, the police department, the fire department, EMS, they deal with these issues on a routine basis. And there's clearly legal authority when an incident is involving, that's not correct, unveiling itself, evolving, that was the word I was looking for, thank you. When a situation is evolving, to control that scene. I mean, we do that on an everyday basis. If there's a fire, you got to keep people back, you got to keep people away. There's clearly a public safety component here that can be utilized. However, if this is a large radiological incident that's going to unfold over the course of days, weeks, months, years, at some point it's a stretch to use that emergency response authority when these issues begin kicking in. So can we leverage systems that are in place now with our colleagues in police, fire, EMS? Can we figure out at what point do we need to elevate that response and actually bring in more legal authority? And also, do we have the backing of our legal colleagues to make this stuff happen? So I've left us a good bit of time for discussion, but in conclusion, a response to a radiological incident is a multidisciplined effort. Obviously, you're going to have law enforcement, local health department, police, fire, radiation subject matter experts, EMS, legal representatives, other stakeholders. And really, this should be used as a conversation starter in your local jurisdiction to talk about what is our authority, how can we take the authority that exists and work that into our existing plans and responses. If you're a state that's limited to biologics, is there a conversation that we can have with the city council or with the state legislature to help modify some of this language? And what can we figure out before an incident happens? And that's really the key to all of this stuff. So I guess with that, I'd like to open it up for discussion, some questions. I know that there's probably some people out there. If it's helpful, I can go back to some slides. I can put the maps back up, whatever you guys would like. So I guess at this point, I'll ask the operator if there's a way that folks can participate, ask questions, etc.
Certainly. Ladies and gentlemen, if you would like to register for a question, please press the 1 followed by the 4 on your telephone. You will hear a 3-tone prompt to acknowledge your request. If your question has been answered and you would like to withdraw your registration, please press the 1 followed by the 3. If you would like to ask a question, please use the chat feature located in the lower left corner of your screen. One moment, please, for the first question. And as a reminder, on the phone lines, if you wish to ask a question, please press the 1 followed by the 4 on your telephone. And there seems to be no questions over the phone line, sir.
Okay, well, I noticed a couple of our colleagues are in the room, so if our colleagues who've worked on this project with us would like to hop in and have any remarks or comments, I'd certainly welcome that at this time. I guess they could probably use the same mechanism. I did see the question about the copy of the slides. I believe, Meredith, and correct me if I'm wrong, but this will be archived and available for future viewing on the NAR website.
Yes, Andy, that's correct. It's radiationready.org, O-R-G, and so you can check back there, and the slides will be available there. Thank you. We do have a question actually coming in through the chat feature. Is there an ability to decon patients, then get retroactive immunity once a government declaration is done?
All right, so the question is there ability to decon patients and then get retroactive immunity once a government declaration is done? Well, the good news is that, generally people that are working on these types of incidents, emergency response, etc., we enjoy a very broad immunity protection. So I think generally that question probably won't come into play. The situation or scenario I really see that question coming into play is that where you have someone who you flagged as being contaminated, you want to decontaminate them, and they're peaking their meters, you know they have decontamination, and they're outright refusing to let you do anything. That's probably the most tricky scenario, and I know there's been some incidents out there throughout the world where in particular folks go for medical treatment and they get an extra dose, or they get too big of a dose of radiation, and then the next thing you know someone wants to shave their beard because their beard is radioactive, and how do you fight that? And in general, those types of real sticky situations, you'll have to really look at your local and state laws. Some states do require that before you can forcibly decontaminate someone that you have to go and get a court order. And again, that's a protection because you are, in essence, invading and doing an invasive procedure, taking away that person's civil liberties. And so I don't know. The retroactive thing, again, we do enjoy good immunity protections during emergency response decisions. I mean, as long as you're behaving within well-accepted standards and practices and not doing something that's completely ridiculous, most of the time we do have immunity protections that are granted to us at the state and local levels. So hopefully I answered some of that question. Someone wants to see the last slide.
Andy, we also have another question coming in. Where do the EPA protective action guides fit into these different scenarios?
Well, the EPA protective guides they're great. I mean, they're a great resource, and definitely when you look at time distance sheltering and protective PPE and all that stuff, they're obviously a go-to source for information. Unfortunately, they don't really delve down into this state-specific legal issues. So while they're good to guide your decisions and guide your response efforts and your planning, I haven't really seen the legal authority being examined or explored within those documents. So I think they're good for broad knowledge, and I think they're good to help aid in planning. But again, the legal authority is kind of a specific question that we're dealing with here that you'd have to examine at your own state and local level.
We have another question regarding the issue of confiscating potentially contaminated personal items. Is any of that addressed in these legal powers?
We didn't talk about the confiscation. We were really focused on human beings in this part of the presentation and part of the research. That being said, we are going to continue on and look at these issues, but we didn't talk about like cargo or inanimate objects at this point.
Okay, thanks. There's also a request to see the slide about restricting movement.
Okay, that should be on the screen now.
Thank you. And then after that one, there's also another request to see the last slide in the presentation.
Okay.
Sorry. Are there any questions coming through the phone lines?
No, we seem to have no questions at this time, ma'am.
Okay.
And Neil, I appreciate your comment in the text box as well. It's very true.
I guess we'll take one last call.
Oh, go ahead. I'm sorry.
I was going to say we'll take one last call for questions. If there's any other please have any questions, please use either the phone or the chat feature. We do have a question about folks entering from overseas.
Well, the folks entering from overseas is a whole different ball of wax. As we've kind of discovered with the MERS-CoV and the H7N9 and H1N1 and all that other good stuff. So the federal authority to prohibit the entry of folks to enter this country is kind of a different ball of wax. They do have authority through Customs and Border Patrol, through the immigration channels, and through the quarantine stations at the ports of entry to prohibit you from actually entering the country. And that kind of turns into more of a federal / border patrol / law enforcement type situation when that does occur. So that's kind of a whole different question, and there is some federal authority around that. But interesting that the domestic flights, the flights that fly every day from Florida to California, Nevada to Chicago, whatever, most of those are governed by state and local rules. At least these kind of issues would be handled at the state and local level. But a good question on the entry of folks from other parts of the world coming into the United States. And that would be a federal authority that they would work out.
Thanks, Andy. We do have a question, or more of a request, if you could read the color coding on the map. Someone's having some difficulty actually seeing that on the slides. If you could go through the different meanings of the colors.
Sure, absolutely. So the beige, the brown kind of looking color is express authority. And again, that's laws that are on the books that specifically call out radiation. So you have express authority for radiation. The map colors that it's the purple color is broad authority. So very broad authority, such as the health department has the authority to protect the public's health by whatever means possible or necessary. The yellow is narrow authority, and that was like the one example in North Carolina where it's a requirement of if a terrorist event occurs, then, we have this authority. So that's a narrow authority for a certain circumstance or situation. And then the blue is the limited to biologics. So that's the laws that say, communicable disease, stop the spread of disease, stop people contaminated with certain kind of diseases. That's more of a biologic type law, and that's typically hasn't been read to include radiation. The states that are kind of multi-shaded, that means they could arguably have some of both types of authority. And we know attorneys love to argue, so you can argue each way on that, or they have some provision that's a little bit different from the rest of the country.
Thanks for that, Andy. We have another question about where does this discussion go next, given that the states don't seem to have a common set of standards. Do you see, is this discussion going any one direction in the future?
Well, I mean, that's a great question. And quite honestly, when we set out on this project, we didn't know what the heck we were going to find. We didn't know what was out there. So now that we have some solid data about what the landscape looks like, I think this could go a number of different places. We're certainly interested in just enhancing awareness about what kind of authorities on the books. Again, I think if you're in a state that's limited to biologics, there might be some opportunity there to work with your either city council or state legislature. And sometimes it's as simple as just adding a word here or there, adding in radiation to make sure that that communicable disease section also includes and addresses radiation. I think there's a tremendous amount of opportunity to partner with our judge and our judicial system, and as well as our attorneys, to talk about these issues and figure out, we have a response plan on the shelf. Do we have the legal authority to do this? If I were to quarantine or isolate, would I have to get a court order? How do I do that? What's the process? Is there a way to get an emergency order issued at 3 o'clock in the morning? What's the judicial review on that? What's the notice requirement? Is there a hearing requirement? Is there some kind of a penalty? Do we have to afford this person an attorney? All these discussions, I hope, will start to play out because of this research, and as we continue to socialize this and promote this, I hope to see some of those conversations take place, and hopefully we'll see some change in some of the states, and maybe we'll see some broadening of the laws to address these issues.
Some additional questions from the chat feature. How can states have two different authorities? For example, if there's a broad and a narrow authority in the same state, how does that how does that work?
Well, some of the states, again, as much as we've tried, just because of the way the law is, they don't necessarily fit well within one single category. So you would have to go and actually look at the language, and I'm sorry I don't have the actual language pulled up in front of me, but it would be something to the case of they have limited to biologics authority except for a terrorism event, or except for in the event of a bad pandemic, or except for if a national emergency is declared. But again, we do have all the stuff referenced. I don't, unfortunately, have the language right in front of me to better explain that. But I can get back to you on that for sure.
Thanks. Another question regarding the authority. Does it uniformly lie within the health department, or does it sometimes fall within other disciplines?
That's a great question. And it 50 different states and quite a few different ways of doing things. Some states, I would say the majority lie within kind of your public health code or section of your state laws. But again, that's not uniform throughout the country. Some of the states we saw had this more in the, some states have, especially those with power plants, have them in language governing power plants and governing regulation of power plants. Other states we saw had them more in a kind of homeland security type section of their code. So typically I'd say as a general rule, you can, if you want to start looking, you can find them in the public health section. But again, your mileage may vary with some of that. Thank
you. And were findings, did you see any difference in findings for New York City and or Washington, D.C.? Was there anything unique?
I know that New York City had the same or broader authority than New York State, and Washington, D.C., Washington, D.C. is kind of a unique island that does its own thing, but they were right on par with the rest of the country. So there wasn't really anything too unique that stuck out. Now that being said, we recognize that there's local jurisdictions that have home rule authority, and we didn't dive down into every single local jurisdiction because we'd still be doing the research. But we do suspect that some cities or localities with home rule, there may be some nuance there where they may have broader powers in the actual state that they're in. So there may be some nuanced differences there, but we didn't notice any with New York City and Washington, D.C. or Los Angeles.
Thank you. One more question. Is it realistic to hope that one federal law will be implemented to deal with legal emergency handling? Have you seen any trending towards a federal movement on that?
Well, again, unfortunately, because of the vesting of this authority at the state level, it would be unusual for a federal law to come out that would deal with this issue. It's really a state-by-state authority and a state-by-state legal issue that has to be dealt with, just because that's where the authority for these kind of things are granted. So unfortunately, no, I don't think that's an easy fix, unfortunately. I mean, much in the same way where you get your nurse's license or doctor's license or paramedic license from the state, again, because of that grant of power, this would have to be dealt with at the state level as well.
Great, thanks, Andy. I think that may be the last of our chat questions. If anyone else has any questions, please use the phone line or the chat feature.
And certainly happen to talk to anybody offline. My contact information is up there on the screen. Give me a call, give me an email, send me a tweet, whatever you want to do. I'm very happy to engage in these issues and talk further about you. I know it's a kind of a technical issue and a lot to digest in a webinar, but very happy to talk with you offline.
Great. Thank you so much, Andy, for your presentation today. It was really informative, and we appreciate it. The webinar, again, will be archived on the NAR site, which is www.radiationready.org. And we will sign off. Okay, thank you.
Ladies and gentlemen, that does conclude today's conference call. We thank you for your participation and ask that you please disconnect your line.